How to put a house inside of a trust without using an attorney. If you want asset protection for your house, or you want it to avoid the probate process when you pass away and go directly down to your family instead of getting stuck in the probate courts, you can put your house inside of a trust, but you don't need to spend thousands of dollars on a trust attorney just to be able to put the house inside the trust. This video is going to show you exactly the steps that you need to take and the things that you need to think through when putting your house inside of a trust so that you can do it yourself. So the first step is understanding what putting your house inside of a trust means. And so when you put your house inside of a trust, you no longer own that property because you have transferred ownership out of your name into the name of the trust, and now the trust owns that property. You no longer do. Now, depending on the type of trust that you choose, you can still maintain control over the property that's inside of that trust. So with a revocable trust, which avoids the probate process, you can still be the trustee and have full control over that property. You can buy or sell properties inside of that revocable trust, but with an irrevocable trust, generally you cannot be the trustee, meaning you have no control over the property inside of that trust. You will have to choose another person to be the trustee, and then you will be able to control how they manage and distribute that property via the trust document. But when the house is inside of a trust and you pass away, that property will not have to go through the probate courts to be distributed out to your family. So that can save your family up to a year or up to $10,000 to $15,000 on the probate process. Step number 2 is creating the trust document. So you can use a service like LegalZoom or trustandwill.com to create a trust document for your house. The things that you need to take into consideration is the type of trust that you're going to be setting up. So a revocable trust avoids probate, an irrevocable trust will give you asset protection and also avoid probate. With the revocable trust, you can be the beneficiary and the trustee. With the irrevocable trust, you generally cannot be either one. As an example, a trustee would be the person that would sell a house inside of a trust. A beneficiary would be the person that would take distributions from the proceeds of that sale. And so on your trust document, these are some of the things that you need to include on that trust document to make sure that it's a valid document. And the first one's going to be your name and the date that you are creating that trust document, who the settlor of the trust is, which is you, the person creating that document, who the trustee is. If it's you as a revocable trust, put that in there. If you're choosing another individual for an irrevocable trust, you would put that in there. Same thing for the beneficiaries, you just put who those beneficiaries are. You would also list a successor trustee. This is going to be the person that will step in your role as trustee in the event that you become incapacitated or you pass away. They will be able to immediately step in your role and take over the management of the assets inside of that trust. And then you're going to outline the powers that the trustee has. So can they buy and sell properties? What do they do with the money from the sale of that property? Do they reinvest that money, distribute that money, or buy a new property? You'll need to include the instructions on how those properties should be managed and then distributed out to the beneficiaries. Once you have your trust document set up, then you're going to print it off and sign it per the local laws for Georgia. And so that means you have to sign it in front of a notary and 2 witnesses. If you do not do this, it will not be a legally valid document, so you have to sign it correctly. The third thing that we're going to do is prepare a quitclaim deed, which will transfer the property into the trust. And so what you're going to do is find the quitclaim deed on LegalZoom or trustandwill.com. You fill that document out with your name and the name of the trust, and then you'll put a legal description of that property on that document. You'll print that document out, sign it in front of notary and witnesses per the laws in Georgia, and then you will file that document with the county clerk's office. And what that is going to do is transfer the ownership of that property out of your name into the trust that you just created. At that point, your trust will be fully funded, and now the trust will own that property and you will no longer own that property. Now, so far we have created our trust and we have put the property into the trust, and now everything is set up correctly. We have put our house inside of a trust without using an attorney. And so there are still more steps that we need to take to manage the properties inside that trust. The first one is going to be updating your insurance. And so your insurance company has the right to not pay out any claims on the property inside of a trust if you have not updated your insurance correctly. And so the reason being is that when you set up your insurance policy, the agreement that you have with the insurance company is that you will be the owner of that property while that policy exists. The problem is going to be is that you have transferred ownership to the trust, and now the trust owns it and you no longer own that property, which breaks the agreement that you have with the insurance company, and it gives them the right to not pay out any claims on that property. So what you need to do depends on the type of trust that you have. If you have a revocable trust, you will add the trust as the additional insured on that policy. You'll still be the named insured. You'll be in control of the policy, paying the premiums and filing the claims. And then if you have an an irrevocable trust, you will cancel the policy that you have, and the trustee of your irrevocable trust will create a new insurance policy, and then the irrevocable trust will be the named insured on that policy, and the trustee would be the person that manages that policy, pays the premiums, and files the claims for that property. The next thing is going to be how to handle the mortgage if you have one on the property. So the thing that most people are concerned about is triggering the due on sale clause, which basically gives your lender the right to call the remaining balance of your loan due if you have done this incorrectly. And so again, this depends on the type of trust that you are setting up. With a revocable trust, which only avoids the probate process, you will not trigger the due on sale clause. They will not call the remaining balance of your loan due. All that you need to do with the revocable trust is notify your lender that you have put the property inside that revocable trust, and they will update their records on their side. Now, the one that gets hairy is going to be the irrevocable trust. So the irrevocable trust, which gives you asset protection and avoids probate, will trigger that due on sale clause, and the banks will call the remaining balance of your loan due. And so if you are going to put your house inside of an irrevocable trust for asset protection from things like lawsuits, divorce settlements, or Medicaid, what you need to do is talk to your lender before you put that property inside of that irrevocable trust, because if you put it in there and you don't have any ability to get it out, they will call the remaining balance of your loan due, and you're going to be in a financial pickle. And so when you go and talk to them before you put it inside the irrevocable trust, what you want to do is one of three things: either get permission from your lender, refinance that property into the name of a trust, or pay that property off completely so you do not have to worry about your lender calling your loan due. The next thing is going to be for the homestead exemption. So you can maintain your homestead exemption when you put your house inside of a revocable trust, but not for an irrevocable trust. To maintain your homestead exemption, you just file the affidavit for the homestead exemption when you put your house inside of a trust. And you'll need to file that with the county before April 1st so that it updates your taxes. And the last thing is going to be making sure that you're keeping everything organized. So you'll need to make sure that you're keeping the original trust document, not a copy, safe. That way, in the event that you pass away or you need to go to a lender or the bank or whatever reason, you have that original copy, which is going to prove that you have your assets inside of that trust and that you are able to manage your assets inside that trust. And then you want to give copies to your trustees and potentially the beneficiaries, but specifically for the trustees, so that in the event that you become incapacitated or you pass away, they have a documentation showing that they have the authority to manage the assets inside of that trust, and you want to let them know where that original document is at. You also want to keep the affidavit for the homestead exemption, your mortgage documents, your insurance documents, and all those other filings in one location so that they can be able to find any of that information when the time comes. So that was a step-by-step process of how to put your house inside of a trust without using a trust attorney. Obviously, it's a good idea that you have a trust attorney review your trust documents before you set them up, sign them, and then put your house inside of that trust. The reason being is that things become permanent, whether it's a revocable or an irrevocable trust. While you are alive, you can change your revocable trust, you can amend it, you can cancel it, you can do whatever you want with that revocable trust. But when you pass away, that revocable trust turns irrevocable. If you have set things up incorrectly, that's a permanent structure, nothing can be changed. The same thing goes with an irrevocable trust. If you set up incorrectly, things will be stuck inside of that irrevocable trust, and no one will be able to get the properties out of that trust when you pass away. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team.